Ascent Audio, a division of Recorded Books, presents The Federal Courts, An Essential History by Peter Charles Hoffer, Williamjames Hull Hoffer, and N.E.H. Hull. Narrated by Adam Verner. Foreword. One of the missions of the Federal Judicial Center, in addition to overseeing research and education for the federal judiciary, is to conduct, coordinate, and encourage programs related to the history of the judicial branch of the federal government. When the Supreme Court Historical Society suggested that we collaborate on a one-volume history of the federal courts, we immediately and enthusiastically agreed. We were pleased to find and work with three eminent historians, Peter Charles Hoffer, Williamjames Hull Hoffer, and N.E.H. Hull, to produce this magnificent history. Works that explore political, economic, social, and cultural currents in the history of our country too often exclude the federal courts. At the same time, historical writing about the federal courts too often has failed to situate their development in a broader context. This book endeavors to explain the role of the federal courts in our broader national history, both how the courts helped to shape it and how they were shaped by it. Federal courts often make decisions that affect not only the parties before them, but also political, social, and economic issues of local, regional, national, and even international importance. The evolution of the federal courts, and even their existence, was not preordained. How and why did they develop as they have? Who were the men and women whose thoughts and efforts contributed to making the courts the unique institution they have come to be? It has been our pleasure at the Federal Judicial Center to collaborate with the Supreme Court Historical Society, particularly David Pride and Claire Cushman, and with the authors on this ambitious and valuable project. We hope that this book will enhance understanding of the rich story of the federal courts, and spur additional interest in the study and exposition of the third branch. Jeremy Fogel, Director, Federal Judicial Center, November 2015. Preface. At first it seemed that the Supreme Court Historical Society had asked us to perform an impossible task: write the history of the entire federal court system, its personnel, procedures, achievements, output, and failures, for both general audiences and legal professionals, in the space of a single volume. It was only with great humility and trepidation that we agreed to try. We adopted and have tried to follow a number of housekeeping rules to structure our research and writing. While much of what we needed to cover required technical language, we knew that general listeners were unlikely to understand such explanations without help. We determined to simplify as much as possible, without sacrificing accuracy. The best-known members of the federal court system are the justices of the U.S. Supreme Court, and the rule of recognition gives their jurisprudence pride of place in any account of the federal judiciary, because it is the template for lower courts' decisions in cases involving similar issues. At the same time, the lower courts are in many ways even more important institutions, for they are the face of the federal judiciary for the vast majority of litigants and litigators who seek redress in federal courts. A history of the federal courts is a history of people who serve, but there have been too many members of the federal judiciary to provide even capsule biographies of every federal judge in a work such as this. This volume profiles those judges and justices who we believe played the most important part in the story of the courts. The Federal Judicial Center website, fjc.gov, has biographies of all Article III federal judges at fjc.gov/history/home.nsf/page/judges.html. There is a vast array of secondary literature on the federal courts, most of it law review pieces, some of it in books, administrative government reports, and other sources. Including more than a small portion of these in the notes would overwhelm the narrative and unnecessarily puff up the citations. Where portions of these secondary sources are especially relevant, or the source for an argument or quotation, they appear in the end notes. A bibliographical note at the end of the work is a very brief guide to research in the primary sources, for we recognized that sound historical scholarship rests on primary source research. judicial opinions, and other public records are in print and online, as are the texts of statutes. The Library of Congress, the National Archives, and the National Archives and Record Administration regional depositories are treasure troves for unpublished manuscript materials. One could spend years in the archives and never do full justice, either to their holdings or to a book project like this. Self-imposed selectivity was necessary in using all of these sources. So too the newspapers, the correspondence of the judges, and other traditional historical primary sources had to be mined, but only a small selection could be included here. Selectivity also demanded that we determine criteria for the inclusion of cases, institutional information, content of statutes, congressional debates, judicial biographies, and other materials. We adopted 4 rules. Contemporary significance was the first criterion for inclusion. If it mattered to men and women at the time, it belongs in this volume. Second, subsequent or lasting impact on the development of the law or the institutions of the federal judiciary weighed in our calculations. The third criterion was how clearly the judicial event illustrated or reflected a time and place in history. Finally, we selected anecdotes about cases that we hope will especially enhance listeners' understanding of the work of the federal courts. We gave more space to these than to other cases, because in our thinking, they are what law professor Carl Llewellyn called cases of trouble, cases wherein basic values or customs are at stake. The narrative is divided in 3 parts, according to the expertise and interests of the authors. Peter Charles Hoffer is largely responsible for the first part, Williamjames Hoffer for the second part, and N.E.H. for the third part, although the authors collaborated throughout the course of the research and writing. All read and commented on each part, and the final version bears the imprint of all 3 authors. It is a rare treat for listeners and authors of histories when they can tap the expertise of those who had inside knowledge of the story, and even more important, helped frame it. Russell Wheeler, as a former deputy director of the FJC, a post that John S. Cook now holds. Both were in a unique position to observe the evolution of the federal courts from the 1980s to the present. The authors are delighted and honored that John and Russell have contributed an afterword to this history, covering that period. Finally, a due humility imposes a warranty of use. Writing books is always a learning experience for authors. In the course of learning more about the federal courts, we discussed among ourselves 2 ways that we might present our story. The first envisioned a great panorama, full of people, places, and events, a vast still life through which we would lead the listener. Textbooks and narratives of long period of time often take this form. We opted instead for a second kind of depiction, a view of a world in motion, constantly changing, unfinished, which authors and listeners together watch unfold. Nothing in this landscape stays the same, and nothing is predetermined. To paraphrase Felix Frankfurter, this sort of essay would be as tentative, reflective, suggestive, contradictory, and incomplete as the perversities and complexities of our nation's history itself. Introduction. Most often the story of the federal judiciary is simply a tale of hard work, of sometimes numbing caseloads and unpleasant travel, of finding order in the chaotic system of state and federal law, local custom, and contentious lawyering. Then again, there are moments in American history when all eyes are focused on what is happening in a federal court, when its bench speaks for millions of Americans, when its decisions change the course of events. Ours is a story of these courts and the judges who served on them, but even more important, first and foremost, overall and throughout, a story of the court's vital part in our history. Our retelling of that history is framed by the location of the courts in the center of what may be visualized as 3 concentric rings. These 3 rings are themes that shape the narrative in the following chapters. The first and smallest of the rings is the system of separation of powers, monitored by checks and balances among the various branches of the federal government. The federal courts are one of 3 independent yet interlocking parts of the federal government. The fundamental, though sometimes contentious relationship among the executive branch, the courts, and Congress in particular, the precise limits of Congress's authority to confer and restrict jurisdiction, to create and modify the structure of the lower courts, make housekeeping rules for all the courts, and at times to engage in direct confrontation with the judiciary shaped the evolution of the federal judiciary. Most of the time, it appears that the checks and balances system is weighted heavily in favor of the other two branches of the federal government. The President nominates, and the Senate confirms appointments to the federal bench, after which the President signs the commissions. Congress can create new kinds of federal courts and add or subtract jurisdiction from all the federal courts, except what the Constitution gives to the Supreme Court as its original jurisdiction. By contrast, the court's check on the presidency and the Congress is far weaker and less direct. The power of the federal courts to declare legislation or executive action unconstitutional is a check employed only with great caution, although courts sometimes call on Congress to revise legislation. A second, wider circle is the federal system itself, in which both the national and the state governments are sovereign. This seemingly awkward design of dual federalism was necessary to secure ratification of the Constitution in the states, but it had the potential to pit federal courts against state courts and legislatures. Alexander Hamilton, an astute and successful practitioner in the New York courts, recognized the potential for this kind of conflict in his Federalist No. 82. To allay suspicions that federal courts would subordinate the states' courts, he told readers, "The states will retain all pre-existing jurisdiction over civil suits, save where an exclusive authority is in express terms granted to the Union, or when the exercise of a like authority is prohibited to the states, or if overlapping jurisdiction would be utterly incompatible." Hamilton made the same points in defense of the federal courts, later at the New York Ratification Convention. This judicial federalism sometimes brought state statute law and court decisions into federal courts, for the Federal Constitution and the Judiciary Act of 1789 and subsequent congressional statutes provided review of state law by the federal courts. State courts could and do use federal law to settle suits as well. Sometimes the overlapping boundaries of judicial federalism brought state and federal judicial authorities into conflict. More often, state and federal courts worked in close accord. The first and second circles are the two prongs of what is now termed the Madisonian Compromise, in reality a series of compromises that Madison and others brokered at the Constitutional Convention of 1787 and the first session of the U.S. Congress in 1789. The framers of these compromises could not, of course, predict how they would work in the long term, but both checks and balances and judicial federalism have proven durable, workable systems. The widest third circle, in which the federal courts operate, is the democratic-republican system of American self-government. The federal judiciary is not elective, and its principal judges serve during good behavior, rather than at the pleasure of Congress, the President, or the electorate. But the independence that lifetime tenure theoretically confers did not and does not isolate the judiciary from political currents, partisan quarrels, and public opinion. Many vital political issues came to the federal courts, and the court's decisions, in turn, shaped American politics. Although the Constitution nowhere mentions political parties, and the framers of the Constitution regarded political factions as something on a spectrum between dangerous cabals and self-interested coteries, parties and politics, and the partisanships they engender, have been a factor of national American political life from the moment that the Constitution went into effect. We are an especially political people, and our public arena demonstrates a conflict limited and regularized, but nonetheless relentless among groups who have contradictory interests and more or less mutually exclusive hopes of securing them. In such a public arena, the courts could isolate themselves from these controversies and conflicts if they tried, but no serious observer believes that the courts are entirely insulated from the currents of political opinion. In the words of turn-of-the-century journalist Finley Peter Dunn's immensely popular alter ego, Mr. Dooley, "No matter whether the Constitution follows the flag or not, the Supreme Court follows the election returns." At the same time, the impact of political ideologies and partisanships on the courts should not be overstated. Many years ago, law professor Alexander Bickel, one of the most astute observers of the federal courts, made the same point. It is never altogether realistic to conclude that behind all judicial dialectic there was personal preference and personal power and nothing else. If it be true, then their authority over us is totally intolerable, and totally irreconcilable with the theory and practice of political democracy. In fact, the judges themselves are the people most concerned that it not be true. As Chief Justice John G. Roberts, Jr., writing for the court in Lannell Yulee Williams v. Florida Bar, 2015, put the matter, judges are not politicians, even when they come to the bench by way of the ballot. The restraints posed on judges by precedent, the judicial code, and norms of ethical conduct also moderate any partisan tendencies. Today, the vast majority of federal judges' background and professional experience leans them toward more moderate stances on public issues than the more partisan players in the political arena would advocate. Operating within these three circles, the federal courts, the least democratic branch in theory, have proved in some ways and at various times to be the most democratic. Open to ordinary people, seeking redress, for example. Litigation in the federal courts reflects the changing aspirations and values of America's many peoples. As Massachusetts Supreme Judicial Court Judge and scholar Oliver Wendell Holmes, Jr. told the Suffolk, Massachusetts Bar Association in 1885, "Judge-made law was a magic mirror, wherein we see reflected our own lives. To this one should add that the decisions of the judges of the federal courts changed those lives." It was a reciprocal arrangement, magic mirrors facing one another, the reflections in each repeated over and over through time. Within the three circles, one also finds epicycles of continuity and discontinuity. The most obvious continuity consists in the overall growth and elaboration of the function of the federal courts. Similarly, one cannot miss the growing administrative apparatus of the courts, including the Administrative Office of the United States Courts, Federal Judicial Center, and United States Sentencing Commission, among other judicial branch agencies. Institutional bodies, like the Conference of Senior Circuit Court Judges, in 1948 retitled the Judicial Conference of the United States, provide counsel to the judicial branch, and, under a statutory framework, abet the administration of the courts. This growth was not linear, the number of judges and variety of courts adapting to the demands on the court system in a simple upward progression. Instead, the growth was punctuated, long periods of increasing caseloads behind which lagged the court's carrying capacity, followed by sudden spurts of activity, in which additional judgeships were authorized. Often Congress did not want to spend more on the courts, or political divisions in Congress, or friction between Congress and the President delayed necessary remedies. The increasing flow of cases the federal courts faced over time is another continuity that accompanied their growth. Since the 1830s, the system periodically was overloaded with civil litigation and criminal matters. The growth of the court system did not accommodate the flood. Overloaded dockets have long concerned students of the federal court system. In 1927, Harvard Law School professors Felix Frankfurter and James Landis published a seminal tract entitled The Business of the Supreme Court of the United States, a study in the federal judicial system. While they lauded the operation of the courts, they worried that the great increase in prosecutions for petty offenses in the federal courts, for which prohibition is largely but not exclusively responsible, has cast burdens upon the federal courts that to no small degree transformed their traditional place in our federal system. 45 years later, Federal Court of Appeals Judge Henry J. Friendly dedicated his Carpentier lectures at Columbia University to the same subject. He found the federal courts faced with a breakdown. The Civil Rights Revolution, a spate of habeas corpus appeals, the war on drugs, and economic and environmental regulatory initiatives threatened to overwhelm the lower courts. Congress was heaping more and more on the court's plate. More judges, more specialized courts, and legislation that gave the Supreme Court almost entire discretion over its docket did not relieve the court's burdens or reduce the danger of a breakdown. As Judge Richard A. Posner of the U.S. Court of Appeals for the Seventh Circuit wrote in 1999, the increase in the district court's cases from the 1970s to 1999, though dramatic in itself, was dwarfed by a rising tide of appeals. He feared that the system was staggering, and the palliative reforms proposed, much less those essayed, did not get to the root of the matter. The discontinuities in the history of the federal courts are perhaps even more striking than the continuities. 3 of them dictate the tripartite structure of this book. The first was the decision the framers made to create a system of lower federal courts. This expanded the federal court system into every state. At the Constitutional Convention, and later during debates over the Judiciary Act of 1789, in the First Federal Congress, many of the framers opposed the creation of lower federal courts. Part 1 of our story follows the elaboration of this system from one end of the country to the other, ending in 1860, by which time the nation was truly continental. The second great watershed was the Civil War and Reconstruction. As a result of wartime and post-war legislation in Congress, the scope, size, and jurisdiction of the federal courts expanded dramatically, ending with the creation of an entirely new tier of appellate tribunals. The expansion of the courts accompanied the shift from a largely rural, agricultural nation, with a relatively small federal government, to a largely urban and industrial giant. The rise of administrative forms of organization also reshaped the structure and everyday operation of the federal courts into something like their modern form. Part 2 traces this story. Part 3 begins with the Great Depression, a time when federal courts faced some of the most critical challenges. New kinds of litigation and litigants reflected sea changes in social and cultural ideas, and these once again remade the place of the federal courts in our history. The boundaries of the parts and the chapters could have been placed differently, but as presently arrayed, the 3 parts conformed to the conventional narrative arcs, that is, the scholarly periodization of American history textbooks. Each chapter surveys a portion of that narrative. As is apparent from the preceding, we do not see the courts as insulated from larger historical forces. The contrary is true. The judiciary operates in the context of national and local politics, economic developments, and intellectual currents and changes with them. The first of these contexts is geographical. The rapid territorial expansion of the nation was soon followed by the expansion of the lower courts into the newly settled areas. First as territorial courts, then as district and circuit courts. The court's accommodation to territorial expansion over time ensured that litigants in the West had access to the same judicial remedies as litigants in the more settled portions of the country. To be sure, diversity in the sorts of cases and a varied ethnic makeup of the litigants coming to federal courts in different parts of the country were reflected in the varied handling of cases in the districts. Such a federalism of outcomes, to coin a phrase, promoted local attachment to the federal system in its infancy, and continues to accommodate the social and cultural differences of different parts of the country. With one early exception, the District of Maine, and one current exception, Wyoming and those portions of Yellowstone National Park, situated in Montana and Idaho, constitute one judicial district. The boundaries of the districts coincide with the boundaries of states in which the district court sits. After holding hearings in 10 cities throughout the nation, Congress's Commission on Revision of the Federal Court Appellate System in 1973 conceded that regional attachment to the various circuits was too strong to recommend reorganizing the boundaries of the existing circuits as a means of adjusting the geographical jurisdiction of their courts of appeals. Members of the bar gave eloquent testimony to the sense of community within the circuit and the loyalty that lawyers had to the existing bench and the law of the circuit. 25 years later, a different statutory commission concluded that the Court of Appeals for the Ninth Circuit was too large to function effectively, but that the remedy to the situation was not to divide the circuit, but to reorganize its Court of Appeals. In any event, Congress declined to do anything. As Court of Appeals for the Second Circuit Judge Irving Kaufman wrote when he introduced a historical exhibit about his circuit in 1977, each of the circuits retains its regional character. At the same time, the hierarchical system of appeals and the fact that judges in one circuit take notice of decisions in other circuits ensured that there would be some degree of finality and uniformity, in turn fostering national unity. Second, cycles of economic boom and bust, in particular periods of economic distress, turned the eyes of debtors and creditors to the courts. Rapid commercial expansion fueled by speculation, followed by rapid contraction due to domestic tight money policy and overseas staple market fluctuations, was a regular feature of the nation's commercial and working life in the 19th century, and to some extent remains so. Federal bankruptcy statutes made the courts into miniature managers of personal and company distress. In times of economic trouble, the business of the courts boomed, causing a crisis of its own, as dockets crowded and caseloads exploded. Third, national political controversies and pivotal elections, including scandals involving officers of the federal government, often landed in the federal courts. From the battles over the Second Bank of the United States in the first decades of the 19th century, to the Watergate scandal of 1972 to 1974, to the controversial handling of suspected terrorists in the first years of the 21st century, federal courts acted as referees in contests over power begun in the other branches. Quarrels and scandals brought a flurry of congressional enactments, for example, regulation of political contributions that federal courts had to interpret. The pivotal elections that most entangled the federal courts included the election of Thomas Jefferson in 1801, with its consequent struggle between Jeffersonian Republicans and Federalists for control of the judiciary, the election of Andrew Jackson in 1828, leading to both federalism and a separation of powers tests of a federal court's authority, the election of 1860, with the ensuing secession of the southern states and the closing of all but two southern federal courts, the disputed Tilden-Hayes contest of 1876, settled by a 15-member commission that included 5 Supreme Court justices, with consequences for the judicial enforcement of the Civil Rights Acts, the election of 1936, followed by Franklin D. Roosevelt's court-packing plan, and the election of 2000, in which the Supreme Court played a decisive role in determining the outcome of the presidential race. Fourth, alterations in the larger aims and activity of the federal government profoundly changed patterns of litigation and the expectations that litigants had about the relief available from the federal courts. These shifts were not a straightforward progression from a weak to a strong federal government, but multiformal, as the commitment of the federal government to play its part in American life shifted, sometimes within an administration. Larger swings in government policy included eras of regulatory innovation in the Progressive and New Deal eras, followed by conservative reactions. In more recent times, as the concept of public rights shifted from an almost exclusive emphasis on property rights to a far broader ideal of both property rights and personal dignity, the federal courts became arbiters of a wide range of civil rights. Then a period of retrenchment and retreat constrained the reformist role of courts. Changing definitions of federal crimes, in particular prohibition in the 1920s, and the war on drugs from the 1970s to the 1990s, and most recently, immigration law enforcement, increased criminal cases on the docket significantly. On top of the spurt in prosecution of drug, weapons, and white-collar crimes in federal courts, a shift in federal sentencing rules in 1984 increased the population of federal prisons eightfold, 25,000 in 1980 to 219,000 in 2012. Fifth, changes in the values of American culture and society. For example, shifting attitudes toward race relations, women's rights, alcohol and drug abuse, the civil rights of gay men, lesbians, bisexuals, and transgendered individuals have impressed themselves on the federal courts. In turn, the revised concepts of law changed how Americans related to one another. A study of history shows that the old adage, "law cannot change society," is wrong. As Martin Luther King Jr. put it, while it may be true that morality cannot be legislated, behavior can be regulated. It may be true that the law cannot change the heart, but it can restrain the heartless. Finally,
Sample complete. Ready to continue?